Yeah, I said to someone today, we might be on now. Maybe not. We've had a fantastic group of competitors. I mean, you guys should. I said to someone today,
How many did we start with?
We've had a fantastic group of competitors. I mean, you guys should.
How many did we start with?
Professor Baxter, I'm showing on my screen, it says live on custom live streaming service, which sounds good. I'm just thinking, not to create a wrinkle, but I am in my chambers in the federal courthouse. I hope there's not some kind of block.
So we are live on YouTube. If everyone could please mute themselves. I think we should be good to go. So welcome everyone here on the Zoom call and all those joining us on the YouTube live link. Thank you all for being here and for taking part of NSU's first virtual competition. This is certainly a first for me and a first for many of us here today. My executive board and I had no idea that when we accepted our positions for the year that we would be hosting a virtual Feinrider. We were hesitant at first and we resisted the idea, but eventually we accepted our fate and we began an immersion in online tutorials, YouTube instructions, hours-long Zoom calls throughout the nights. And we couldn't have done this without our Executive Justice of Competitions, Zoe Andrzejczyk, who really is the heart and soul of this operation. We also want to thank our fearless faculty advisor, Professor Heather Baxter, who has helped us in so many ways, and all the judges who volunteered this weekend. But most importantly, this wouldn't have been possible without our rising 2Ls. As future lawyers, we have to learn how to adapt and excel in any format or situation to advocate for our clients. And our competitors have proven to us this weekend that they have what it takes to do just that. So with that being said, I would like to hand it over to Dean Vollweiler to say a few words and then to Professor Baxter and Zoe. Thank you.
Thank you, Lena. And on behalf of the whole College of Law, I want to say congratulations to everyone. That is one of those overused phrases where we say, congratulations, everyone's a winner. But the fact that this competition has been pulled off in this amazing educational way is a win for everybody in the College of Law. So I want to thank all of the Executive Board of Moot Court, including their faculty advisor, who, as it was pointed out earlier, is an amazing leader with regard to that. So thank you, Professor Baxter. Thank you to all the judges who have given their time over the course of the whole weekend to do this. And of course, as Lena pointed out, thank you to the rising 2Ls. Being a great advocate requires a lot of different skills, but we are all learning these days that one of the most important skills that we all can develop is the ability to adjust and adapt and learn new skills to help the ones we already have and to grow on. And it's very clear that everybody who has participated in the competition, as the competitors, the rising 2Ls, and those running it, and the judges, have clearly demonstrated that skills and that leadership for everyone representing the College of Law. So with that, I want to say congratulations and good luck to our two competitors, and congratulations to everyone. And I look forward to seeing this last great round. Thank you.
Thank you, Dean Vollweiler, and thank you for your continued support of our advocacy programs. We would not have the success we've achieved in recent years without the support of our administration. I also want to thank our new executive board, who just took their positions recently and had no idea they would be charting these new territories when they agreed to serve in these roles. But they have done a wonderful job of getting us up to speed in this, I dare to say, new normal. The practice of law, as Lena said, is not stagnant, and part of being a good lawyer is adapting to change. And let me tell you, these 4 law students have truly shown they are ready for the challenge. Of course, I also want to congratulate the rising 2L students who competed today and yesterday and Friday. Whether you made moot court or not, you made a huge investment in your future by practicing skills that will be helpful to you throughout your practice of law. Now, I also want to take a moment for those of you at home to orient you to the argument that you're going to see in just a minute. So both of these two outstanding students have battled to get where they are today. And in their legal research and writing class, they wrote a brief that accompanied a motion for or against summary judgment. And that motion is actually set before the United States District Court for the Western District of Texas. And generally, this would be in front of one trial judge. And for the purposes of this competition, however, it's going to be a panel of these wonderful 5 judges that we have here today that you're going to hear about in just a minute. And we're doing that to simulate more of what an appellate oral argument would look like. And so what these students will face when they do travel competitions for moot court. So although this is not a true appeal, we will be following most of the procedures as if it were a traditional appellate oral argument. Finally, I want to say that I am so grateful for my colleagues and the fellow attorneys who've given up some of their weekend to judge our students. We really appreciate the patience you've shown and all the efforts this weekend. We would be unable to pull this off without our judges. And so though this has been a great success and lots of fun, we are looking forward to the day when we can all be together again in the law school building. Thanks again, and let me turn this over to Zoe.
So before I introduce not only the competitors and our panelists, we want to give a special thanks to all the judges who did come this weekend and judged our advocates. And please come back for the next one. We could not have done what we did this weekend if it weren't for our guest judges who gave up their time and their patience and the fun that usually comes with judging these sort of competitions. Typically, this takes place in the law school, so it's kind of like a small reunion with all the judges. And this time, obviously, it was through Zoom, so we do lose a little bit of the fun, but nonetheless, they showed up, they did an amazing job, and for that, we thank you so much. So for now, I want to introduce our panelists, and first we have Judge Singhal, who is a district judge of the United States District Court for the Southern District of Florida. Before his nomination, he served as a circuit court judge for the 17th Judicial Circuit in Broward County, Florida, from 2011 to 2019. Before that, Judge Singhal was in private practice early on in his career. Judge Singhal served as a prosecutor in the Office of the State Attorney. Judge Singhal earned his Bachelor's of Arts from Rice University and his Juris Doctorate from Wake Forest University School of Law. Next, we have Anton Marino. Anton is ACLU of Florida's Deputy Legal Director. They joined the ACLU of Florida in June of 2019, initially as a staff attorney in ACLU of Florida's Voting Rights Campaign. Anton teaches advanced legal writing and appellate practice as a member of Nove Southeastern University Shepard Broad College of Law's adjunct faculty. Anton additionally coaches the college's law students in interscholastic moot court competitions. Next, we have Bethany Pander. Bethany is an appellate associate in Greenberg Tarig's Miami's office, where she focuses on appellate matters, commercial litigation, and trial support in state and federal courts. In addition to winning this very competition as a 1L, Bethany served as Chief Justice of Moot Court in her 3L year here at Nova, and she was the valedictorian of her graduating class in 2018. Next, we have Jennifer Bautista. Jennifer is a judicial law clerk to the Honorable Melanie May at the 4th District Court of Appeal. Ms. Bautista graduated in the top 3% of her law school class at Nova Southeastern University in 2019. She was also the executive justice for competitions in moot court. James Foster is an associate at Wicker, Smith, O'Hara, McCoy, and Ford, where he focuses on automotive, premises liability, and commercial litigation. Mr. Foster graduated law school with honors from Nova Southeastern University and was also a Feinrider champion and previous Chief Justice of Moot Court. Thank you so much for our final panel for being available and appreciating what we've done today and this whole weekend. Before I introduce the finalists, I just want to thank everyone once again. We are all pioneers in hosting Nova Southeastern University's first virtual Feinrider competition. And although that was the scariest thing to hear when we were deciding that this is what we were going to do, I'm so glad that we ended up doing it, and it ended up being an amazing, such an amazing time for everyone. And I think it was quite enjoyable. So right now I'm going to introduce our finalists. And first we have Lucia Rodriguez, and she will be the movant. And next we have Kyle Forge, who will be the non-movant. And now I'm going to pass on the torch to our bailiff of the round, Zachary Stoner.
How much time would the moving party like to set aside for rebuttal?
1 minute, please, bailiff.
Absolutely. Okay, and now, judges, if you are ready, I will begin opening remarks. I just want to remind everybody, once again, we are in the United States District Court for the District of West Texas. We are not in the United States Supreme Court, despite what you're about to hear. With that out of the way, oyez, 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 all persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for this court is now sitting. God save the United States and this honorable court. I will now stop sharing my video and we'll begin to share my screen. Can everybody see that there is a timer displayed on their screen right now? Perfect. Then I shall mute myself briefly, and judges, you can have the floor. Competitors, I will start the timer as soon as you begin speaking.
Chief Justice, Your Honors, and may it please the court. My name is Lucia Rodriguez, counsel for the City of San Antonio and the San Antonio Zoning Board. We respectfully ask this court to grant the motion for summary judgment for the following 2 reasons. First, the San Antonio Zoning Board's selection of prayer givers is traditionally appropriate. And second, the San Antonio Zoning Board's prayer practice is not coercive. If it was good enough for the first Congress 200 years ago, then it should be good enough for the San Antonio Zoning Board today. The Supreme Court has told us in Marsh versus Chambers that an unambiguous and unbroken history of more than 200 years leaves no doubt that the practice of opening legislative sessions with prayer has become part of the fabric of our society. The first Congress, while drafting the language of the First Amendment, began their very own session with a prayer, noting that the prayer serves to solemnize congressional meetings and to unify those in attendance.
Counsel, but isn't there a distinction to be drawn between the first Congress and what the zoning board does? If I recall, the first Congress actually had a chaplain offer prayer, whereas here the zoning board has its own members offering prayer in public meetings.
Thank you for that question, Your Honor. And both Town of Greece and Marsh versus Chambers, which were recently decided, Town of Greece in 2014, upheld the constitutionality of this tradition that was long held, that has been followed 200 years ago. Specifically, the purpose of the prayer is to solemnize those in attendance.
Right, but counsel, in both of those cases, wasn't it a third party, a clergy member, and then a chaplain who gave the prayer rather than a council member?
Yes, Your Honor, but neither Town of Greece nor Marsh versus Chambers restricts who may give the prayer. As long as the prayer comports with that tradition, as I articulated, to solemnize the occasion, it will be held as constitutional.
But doesn't San Antonio restrict who officiates the prayer, council? Isn't it limited to members of the board?
Yes, Your Honor. Pursuant to Rule 17, the rule stipulates that by majority vote of the zoning board members, the next zoning board member will give the invocation at the next meeting. This is very distinguishable from Lund versus Rowan and Williamson versus Brevard County, where the selection of the prayer givers was arbitrary and exclusionary. Here, the zoning board follows Rule 17 to a T.
Right, but Counselor, isn't Rule 17 itself exclusionary in that it limits the pool of potential prayer givers to those that are on the board, who we know are majority Baptist?
Thank you for that question, Your Honor. And Town of Greece articulates that so long as the town maintains a policy of non-discrimination, their prayer practice will be held constitutional. Here, the zoning board has never received and therefore cannot refuse a request from anyone offering to give an invocation, making their
I just want to be clear on one point. Is it San Antonio's position that let's assume, for the sake of argument, that the policy is indeed facially non-discriminatory? Is the city's position that it can't still be discriminatory in application or practice?
Well, thank you for that question, Your Honor. And the policy, Rule 17, is not discriminatory because they don't discriminate and they don't restrict anybody. For instance, in contrast, take Lund versus Rowan County for the Fourth Circuit. Lund actively had no written policy, making their selection process arbitrary. Here, the zoning board, in fact, follows their rules, making it not arbitrary or discriminatory, and making it in line with the constitutional framework articulated by the Supreme Court in Marsh and in Town of Greece. The first Congress, as
but isn't it something to be said? Isn't there something to be said, though, that the policy, and we can get into intent in a moment, but can't we at least say that the policy maintains a discriminatory impact at minimum, because the only prayers that have been offered are prayers that are being offered by members who are indeed Baptist?
Right, and to that end, isn't that a question of fact that we need to review?
Well, Your Honor, first, with regard to Rule 17 specifically, it's not discriminatory because the town has never received a request from anyone of any faith offering to give the invocation. Furthermore, the Supreme Court has never restricted in Marsh and in Town of Greece who may give the prayer. And legislative-led prayer by legislators themselves has been held to be constitutional. For instance, in Bournemouth versus County of Jackson, they held that the legislative-led prayer was in fact constitutional.
Counsel, is it your position that basically any discrimination, if there is any, is handled at the ballot box? And so whoever's elected, that's up to the voters, and if they elect all Baptists, that's going to govern who gives the prayer?
Not necessarily, Your Honor. What I'm saying is that the zoning board actively took the time to compile this rule so that they can comport with the constitutional restrictions given to these towns, such as the one that I've distinguished in Lund versus Rowan County, where there was no written policy. The lack of this written policy begs the question that these legislative-led commission-based prayers were arbitrary and in fact discriminatory because they excluded other faiths.
But counsel, don't the facts in Lund and Bournemouth also suggest that the board's action here is indeed even more egregious, right? Because in both Lund and Bournemouth, the board rotated who was providing prayer. In this case, the board affirmatively decides by majority vote who will indeed be providing prayer. And if someone of another faith is in the minority, they're silenced.
Not necessarily, Your Honor. The record indicates that the zoning board is not only comprised of Baptist members. The zoning board is also comprised of Episcopalian, Muslim, Greek Orthodox, Christian Scientists, not strictly Baptist. The fact that
any of them ever been selected, Counselor, to give the prayer?
No, Your Honor, not yet. But there is always the opportunity by the democratic form that they have chosen to incorporate Rule 17 by voting for the next speaker.
Well, let me ask you this, counsel. Isn't it possible that even in exercising a democratic process, that lawmakers or board members may actually be engaging in some form of discriminatory motive?
Your Honor, there are no facts to substantiate that. The fact that there is a rule and makes their policies not arbitrary and discriminatory, and because these policies of commissioner-led and zoning board-led prayers have been held to be constitutional by the Supreme Court. And as to my second point, the zoning board's invocation does not violate the Establishment Clause because it is not coercive. Justice Thomas in Town of Greece noted that to the extent coercion is relevant to the Establishment Clause, it is actual legal coercion that counts, not the subtle coercive pressures felt by a plaintiff.
Here, counselor, we're not looking at subtle pressures, though, when all of the people that are present at the meeting are invited to stand, hold hands, and participate. And isn't that really the issue here?
Respectfully, Your Honor, no. Those commonplace and reflexive actions has been held in Town of Greece, recently decided in 2014, that those are just reflexive and commonplace directives, and that those directives alone do not indicate a pattern and practice of coercion. Your Honors, I see my time is up. May I briefly conclude?
Yes, 1 minute.
Thank you. Therefore, for the foregoing reasons, the City of San Antonio and the San Antonio Zoning Board respectfully request this court to grant the motion for summary judgment. Thank you.
Thank you, counsel.
Everyone, real quick, just before the non-movement goes, I'm just going to adjust the screen so everyone can see the competitors and not just the timer. Give me 1 second. Trying it like this. Can everybody still see the timer? Yes? All right, perfect then. What was I gonna say? Non-movement, whenever you begin speaking, I'll start your timer.
May it please, Chief Justice, Your Honors, may it please the court. My name is Kyle Forges and I represent the respondent in this case, Dr. Frank Zola. Your Honor, we respectfully request this court deny Movement's motion for summary judgment because judgment is not appropriate as a matter of law. As seen in the Federal Rules of Civil Procedure, Rule 56, summary judgment is appropriate when there are no issues as to material fact and judgment is appropriate as a matter of law. For the following 3 reasons, judgment is not proper according to law. First, the Establishment Clause was violated by the speaker selection process as indicated in Rule 17. Second, the prayer practices were coercive in nature. And third, as a matter of public policy, sectarian or denominational prayer should not be allowed at zoning board meetings. Moving to my first point, Your Honor, the Establishment Clause was violated by the speaker selection process because only Baptist prayer was consistently delivered at these zoning board meetings. As seen in the Supreme Court case of Town of Greece versus Galloway, which was decided in 2014, the Supreme Court gave us a test to determine whether legislative prayer practices violate the Establishment Clause. That test evaluates whether there are intentional exclusions of other creeds, the conversion efforts of the speaker, and the identity of the prayer giver. Another case.
Right, but Counselor, is there anything in the record to suggest that there was intentional exclusion, as you stated?
Your Honor, since this is a matter of summary judgment, inferences must be determined in the light favorable to the plaintiff, in this case, Dr. Frank Zola. And based on the fact present, only Baptist board members were chosen to give prayer. As seen in Town of Greece versus Galloway, and then in the other Supreme Court case, Marsh versus Chambers, which was decided in 1983, the court evaluated a longstanding tradition of the Nebraska's legislator providing legislative prayer. That prayer practice was over 100 years old. And here, the prayer practice is merely a decade old. Additionally,
but we look, counsel, we look to the entirety of the history of and tradition of prayer before legislative bodies, correct? We don't just simply look at what this specific zoning board did or adopted 10 years ago.
Your Honor, in reference to that point, the prayer practices were adopted recently, and they do not comport with the prayer practices practiced in our nation from our nation's founding. Here, the legislators themselves are giving prayer, the zoning board members are giving prayer, and not members of the community or even paid as seen in Marsh versus Chambers. Here, it is
right, Counselor, but doesn't that actually support less entanglement between the church and state, where we have the legislative body deciding to not spend state money in order to secure a chaplain to say the prayer? So here we actually have more separation because there is no religious leader giving the prayer.
Your Honor, in this instance, there's only Baptist board members giving prayer, and there's a minority prayer religious group on the board that is not granted the opportunity to give prayer.
Counselor, how do you respond to opposing counsel's argument that all of the persons elected were elected through the legislative process, and that there were other members of the board that have had other religions as well, not solely Baptist?
Your Honor, the other religions on the board should be granted an opportunity to be heard as well. As seen in Lund versus Rowan County and Bournemouth versus County of Jackson, two cases that Movement mentioned, both instances revolved around the notion of a rotational basis by which everybody on the county was granted the opportunity to give prayer. But in Lund versus Rowan County, the court analyzed a closed universe in which only Judeo-Christian zoning county commissioners gave prayer in a rotating basis. This is a closed universe here as well, seeing as only the Baptist board members choose within themselves to give prayer.
But isn't it really only a closed universe here, Counselor, because the majority of the population in this area happens to be Baptist, not that there was an intentional discrimination against any other type of religious person to participate either on the board or in the prayer?
Your Honor, although this was a democratic process, Movement mentioned that people have not requested to give a vote to grant prayer, but requests are not evident here as noticed in Rule 17. Only the vote is evidence. So even if a person requested to give a prayer, they would have to be subject to a vote in order to deliver that prayer.
Counsel, I have one question, and it comes down to really how we assess discrimination. When assessing discrimination, are we simply looking to determine whether a subgroup or characteristic is treated differently, or if there's actual animus?
Your Honor, to answer your question, I would like to bring up the idea of inclusion and allowing other faiths to be granted the opportunity to give prayer, not just individuals of one single faith. But moving to my second point of coercion, The prayer practices by the Zoning Board of San Antonio violated the Establishment Clause because attendees were watched as they left and zoning board members took note as they left the room. In the Supreme Court case of Town of Greece versus Galloway, the court gave us a test to determine whether legislative prayer is coercive in nature. This test analyzes the setting of the prayer and the audience to whom the prayer is directed, all against the backdrop of historical tradition.
Counsel, was there any requirement that your client actually be present for these hearings? And if so, was there ever a time where he had to identify his religion?
In reference to your first question, Your Honor, there was an opportunity for Dr. Frank Zola to not attend the meetings, but he did have to attend in order to get his zoning ordinance approved, his zoning ordinance changed. And in reference to your second question, Dr. Frank Zola's faith was never brought up in these instances, but he was trying to open a women's clinic next to the First Baptist Church of San Antonio. And there was talk on the board regarding the fact that he was trying to open a women's clinic in close proximity to a church. But the setting of the prayer must be evaluated. The setting here is in a church meeting room in the First Baptist Church of San Antonio. There are religious ornaments adorning the wall, statues of
Counsel,
Jesus Christ.
does iconography really come into our consideration, right? I mean, government sometimes leases church halls for voting as voting precincts. So why should this be of any import to our analysis here?
Your Honor, we must look at the totality of the circumstances, and that is just one circumstance to analyze. So the setting of the prayer is in the church meeting room, but the audience to whom the prayer is directed must be evaluated as well. And seen in the email from Stan Carruth to Dr. Frank Zola, the commissioner of the head chairperson of the zoning board writes, it should instill careful and cautious action by zoning board members and proper respectful behavior by members of the public in attendance. So the prayer is not directed solely to the zoning board members, but to the prayer in the public in attendance as well.
But counsel, aren't they free to leave the room if they don't want to engage in the prayer?
Your Honor, they are free to leave the room, but there is a moment in which everybody watches who is leaving the room, and zoning board members have even taken notice of who left the room. Additionally,
are they penalized for leaving the room?
Your Honor, there's no indication in the record or in the facts that people were penalized for leaving the room, but if the facts are taken in a light most favored towards the plaintiff, then it can be determined or from a reasonable inference that the zoning ordinance may have been denied because he left the room. But in reference to—
Aren't we just stacking inferences here? I mean, to say that, well, when they watched people leave, they took notes, so therefore the notes must have been about the people leaving, et cetera. Isn't that just going a little too far, Counselor?
Your Honor, I am stacking inferences, but these inferences should be interpreted by a jury. And we are here today on a motion for summary judgment, and summary judgment is appropriate when there are no issues as a material fact, and judgment is appropriate as a matter of law. A jury could rule completely differently than the case's evidence in this case. But moving to my final point, as a matter of public policy, sectarian prayer should not be allowed at zoning board meetings. It is the state adopting a faith and furthering that faith through speech.
But Counsel, isn't the issue of permitting sectarian prayer kind of dead in the water? We have existing precedent, binding precedent from the Supreme Court that indicates that it is indeed permissible.
Your Honor, the Supreme Court cases are not binding on this instance because the Supreme Court cases evaluated whether a paid chaplain, as seen in Marsh versus Chambers, or even a member of the community, as seen in Town of Greece versus Galloway, granted the prayer. This is a case of first impression and should be left to a jury to decide whether the Establishment Clause was violated. A separation of church and state is needed. But I see my time has expired. May I briefly conclude?
Yes, you may.
Your Honor, for the foregoing reasons, we respectfully request this court deny Movement's motion for summary judgment. Thank you.
Thank you, Counsel. And then we'll take some rebuttal from Ms. Rodriguez.
Thank you, Your Honors. Plaintiff alleges that the San Antonio Zoning Board's selection of prayer givers and prayer practice is coercive, and that's certainly not true. According to Town of Greece, which is Supreme Court binding law in this court, the plaintiff must allege a pattern and practice of coercion. This single isolated incident is not indicative of a pattern and practice of coercion.
But isn't there a reasonable inference that can be drawn from the statements that were actually made by members of the board during a public hearing regarding Dr. Zola's absence during prayer, and that his request for a zoning variance was denied following those observations?
Well, Your Honor, first, the zoning board was asking Mr. Surfire if Dr. Zola was present because it's his zoning variance in front of the zoning board. They were merely looking for Dr. Zola. Your Honor, my time is up. May I briefly respond to your question?
Please.
And second of all, the pattern and practice, the law that was stipulated by Town of Greece and the Supreme Court states that there must be a pattern and practice. Plaintiff offers no proof linking the denial of his zoning variance to his objections to the invocation. That's why summary judgment should be granted. Thank you, Your Honors.
Thank you very much, Counselor.
Thank you very much to our competitors and our judges. Zoe is now going to move the judges and I into a breakout room, and we will be back.
One moment. That was a great job, competitors. We're going to make you leave your videos on to have a little bit of anticipation while the judges do deliberate. So keep your game faces or smile or breathe, whatever you need to do, because you guys are officially done. You should definitely be proud of yourselves. It's not easy to be living in the world that we're living in today, and keep your mind straight and focus and practice. And I know you guys have both been preparing for quite some time. So be proud of being on this YouTube live today. You both deserve to be here, and congratulations.
Thank you. These questions were like the hardest I've had to answer. I couldn't even get past that first point. It was difficult.
That's a good thing. That's a good thing. You know, we hoped that the final panel would be something that was a little bit more difficult and intriguing than the last, right? Because this is it. This is how we're going to crown our winner and our runner-up. So if we gave it to you easy, I don't think it would be fair. So we brought the heat, but you guys both handled it really, really well.
Thank you.
Kyle, you did awesome, man.
You did too, Lucia.
Thanks for this opportunity, Zoe, man. It really has been exciting, and like sad that we didn't get to do it during school, but just like Professor Baxter said, you know, this opportunity really has like strengthened. I've never done this before. So it's definitely
for everyone. Don't worry.
It's so uncomfortable, but then, you know, you find kind of, I guess, the wave of it. I don't know. No, you don't.
That's not true. If you didn't catch the wave, you wouldn't be where you are, but there definitely is some sort of high you get from standing up, or not really, I guess in this case, sitting down, but sitting down and making what you got to say happen. And you guys both did it. So I'm going to put myself on mute 1 second.
Kyle.
Hey guys, while we're waiting, so tell me, what was your favorite part of the competition?
My
What
favorite
was the
part.
thing sorry, go ahead, Kyle.
My favorite part of the competition was after round ended and I could go relax.
Was it exactly what you expected, Lucia? Is this what you thought it was going to be like, or totally different?
Oh my God, you would think that being in front of a computer would kind of, make the nerves go away, but it's like, no. And I remember you making this comment during class, how, Zoom world, you don't have a moment to hide behind the curtain. You're always there, you're always on. So, it was nerve wracking, but I think what I was just telling Zoe is that I love that it pushed me to prepare for this type of, for an oral argument. We didn't get the chance to do it in school, in class. So it's been a valuable, super invaluable experience. And I can't thank you both enough for this experience, seriously.
That warmed my heart because I swear I would have not put in the amount of work that I put in if it wasn't because I was so passionate about this organization. And I know exactly where you feel right now and why you feel the way you do. And it is a crazy high that you get from doing an ad, just sitting down and saying what you're saying. It's just when you finish, you're like, wow, you feel so accomplished for yourself, and you've learned more about yourself in the last 10 minutes and all weekend than you felt like you've learned in all of law school. So I appreciate you saying that, because I would not have put in the work that I put in if I didn't know how you were going to feel after this round.
Seriously, I'm very grateful for this opportunity, and I'm happy I made myself do it. I mean, I wanted to, obviously, but it's hard. Like you just mentioned, it takes guts, even behind a computer.
It does, and not everybody, did it. They decided not to do it this time. And then there are lots of people, be grateful for where you are too, and the work that you put in, because obviously not everybody got as far as you did. But there's certainly another opportunity. So I hope that watching this tonight and today really encourages others to try out when it's their turn, because hopefully you have learned a lot from this.
And these judges really kicked our butt, Professor Baxter. The questions were intense.
Tough judges, yeah.
I was just telling Zoe.
Well, you have, some fantastic competitors and judges and attorneys on there. They were really ready for you guys. But you guys both did a great job. I have no idea. I'm so glad I'm not on this panel and that I don't have to pick, because it would be so hard. You guys are both fantastic. And I can't wait for you to compete for Nova and go out there against other schools. You're going to do a great job.
Hell yes.
Thank you, Professor Baxter.
I hope you guys are going to try out for our travel teams. Not that we're traveling anytime soon, but one day we will. And the great news is you can sort of spend this next semester learning about how to be an effective advocate even more, and that when you actually get to go out there, it'll be great.
Professor,
you'll definitely be learning about appellate advocacy, because you'll be signing up for Professor Baxter's Moot Court Appellate Advocacy class. So you'll have a whole semester of Professor Baxter and appellate advocacy before you guys are potentially placed into traveling teams, and by traveling to Zoom from your bed. And do what you guys did today, but with practice and writing a whole other brief. And I've told you guys, every time you do another round, you feel more comfortable, you feel better, you learn more, you learn how to say something in a way that the judges understand and that persuades you and persuades the argument that you're trying to make. So it's only going to make you a better advocate. And if you guys are where you are right now, imagine with practice. Unstoppable is what I would say.
When do you compete? Is it yearly, or is it always a certain semester, or?
It depends on which team you're on. It depends on which team you're selected for. So we have a number of external moot court teams that we field and that compete against other schools across the country. So it depends on which team you get selected for. Because we found out it was a little late this year, we haven't fully selected all of our teams because we wanted to still give those of you that just made moot court the opportunity to compete. So you'll be hearing from us soon. And those of you online watching that can still see us, we will also be doing that shortly. So, and I'm seeing some comments. Anybody have questions for Lucia or Kyle that they want to ask? You guys can comment in the chat on YouTube, and I will pass the questions along to the competitors just while we're waiting. Anybody have any questions? Or there's some great comments. Everyone said you did a great job. It was inspiring. They are excited for you. Trials, Marie, who is our executive justice of team, says yes, tryouts coming very soon for you guys. Lakshmi wants to know how you handle the nervousness being in front of, I'm not going to tell you how many people are watching right now because I don't want to make you nervous. But Kelly says you were both absolutely incredible. So Lakshmi wants to know how you handle the nervousness. Kyle, you want to tell us, how did you handle the nervousness?
I honestly am used to it. I've been doing trial competition since high school, so I just take a breath and just do it. But before competition is when I get very nervous and sometimes even yeah.
Right. So someone wants to know, how long did you prepare for your arguments?
I've been doing this for 3 weeks.
It shows. James, I'm not asking that question. James wants to know what your breakfast meal was, your meal of champions for you. Any other tips for preparation? We have someone who wants to know, what were your tips? How did you prepare?
I think knowing the record inside and out and knowing the pertinent cases, not just the two, let's say, Supreme Court ones, but the more you know, the better the argument will be, in my opinion.
Oh, I love that. That's exactly what I tell my team. So I love that answer. Kyle, how did you prepare?
I had a moot court mentor. I'll shout her out, Sam Reynolds. Met with her every day. She really helped me and pushed me to be better every single day.
Awesome. Shout out to Sam.
It seems like we're missing one judge.
Judge Foster.
Judge Foster, he might be alone in the breakout room.
No, he actually turned off his video, so he may be joining us in a second, but I'll double check.
Okay. Let's give him a minute to walk to this courtroom. It's a long walk from his breakout room to the virtual atrium that we are currently in. So he must be tired. He's slowing down.
I'm going to take my screen off. Bye, guys. Congratulations to both of you.
Thank you, Professor.
There he is. He made it. Thank you, Judge Foster, for making it back to our virtual atrium. No worries. So before I pass it back to the judges to give you some feedback, we're going to make you wait just a little bit longer. I want to announce what the both of you will be winning just for being here. Even if you're not the winner, for running up, both of you will receive a free Themis bar course. So snaps to that. That is extremely expensive. So boom, you guys are checked, ready for the bar in 3 years. Next, you're both gonna get personalized trophies that I will be mailing to you personally. And last but not least, but you get to have the bragging rights to say that the both of you were the finalists in Nova's first virtual Feinrider competition. And for me, I think that is the biggest prize of them all. So congrats to both of you for winning, because you are winners just for being here. So with that said, I want to pass it back to the judges so they can give you some feedback before they announce who the winner is.
All right, I'm going to go first, and thank you, Zoe, for including me and allowing me to be on this panel. I really felt fortunate to be with the other 4 judges, and the 2 of you. I'll just call you Lucia and Kyle, if you don't mind at this point. Really, both are excellent advocates. It's clear that there was a very high level of preparation. The poise and the confidence that you showed here today are really remarkable. You know, many people come to law school thinking they already know how to argue. I was probably one of those, but I wasn't all that confident doing moot court, and you really learn and you really get into it, and being able to craft you know, reasonable common sense arguments, and you both did that. I think you should both be really proud of yourselves, and certainly the 5 of us as judges, our comments are uniform that it really speaks well for the future of our profession to know that the 2 of you are going to be out there advocating for whatever side that you get. Sometimes, you know, a problem is different in terms of which side is better. And I know on moot court, you brief both of them. And so you learn all of the ins and outs. And I felt that you both did just a very nice job, particularly with Judge Marino's questions, because I'm not certain I would have been able to answer all of those. And they were really, really quite good. You know, we joked a little bit. You had 2 hot judges who were really questioning you with Judge Marino and Judge Pander, and then you had Judge Bautista and I, who were relatively quiet, and then Judge Foster did his best to kind of be in the middle there. But really, with 10 minutes to argue and 5 judges asking questions and darting back and forth between what you probably had prepared and answering the questions that were asked, you both did a wonderful job. I'm sure you would have preferred to have done this in person, but when you add Zoom into all of that, just really proud of you both. So I'm going to turn it over to Judge Marino, and we'll circle back before we announce the winner.
Thank you, Judge.
So congratulations to you both. You both did really, really wonderful jobs. And it's challenging argument, especially doing it in a virtual setting, as Judge Singal said, and especially when you're also encountering questions from a panel of 5 judges, which is never easy, because you can try to anticipate what may be asked, but sometimes, you know, you get a question out of left field, which sometimes happens. And I think you both handled questions very well. I will say that I thought you both were very responsive. You were both very thoughtful to the questions, which is good. You know, I'm very excited to see what both of you do in the future. And I look forward to hopefully getting to contribute to your development when you are members of some of the moot court teams at Nova.
Thank you.
Congratulations, both Lucia and Kyle, first on making the Moot Court Society, which as a former member, I am a huge advocate of participation in. So I'm so glad that you guys will get to have this as part of your Nova Law experience. But an extra kudos for being the final 2. It really speaks to your level of advocacy that you've already been able to develop through your 1L year and through this virtual competition. So you should be proud of the arguments that you made today, and over the weekend. I think that both of you did a great job using the record and using the law that you clearly reviewed and understood, and trying to pivot to use those points to really bolster your arguments. And I think that I speak for all the judges that, you know, this is a skill that you already have. And so it's going to be great to see you both develop that with more experience and direction as you continue to grow as advocates. So congratulations.
Hi, everyone. Congratulations again. I'd like to echo everything the other judges said. And I'd like to let you all know that we are so immensely proud to see that this is how Nova's reputation continues going strong, especially for the Moot Court Society. I think that there is nothing but good news on the horizon if we have competitors like you in our society. So I think as advocates, you guys are going to grow to become amazing. And I look forward to seeing how much you guys can learn, not only from doing this competition, but from your career in law school. I think you guys have a real potential to do incredible things one day. And I commend you both for being here, and congratulations again.
All right, just to follow up, because I know all you guys want to hear is who won the round. I agree with everything the judges said. You both were exceptional. Congratulations. It's a huge, huge, huge honor to make it to this final round and to make it on moot court. And I hope that both of you will try out to compete. Those competitions, they changed my life. I mean, they changed my life. It was an awesome, awesome opportunity. But congrats to both of you. Both of you guys were exceptional. I don't know what else I could say. It was really tough for us when we went in our private judges room. So good luck to both of you on your careers.
Before Judge Singhal announces the winner, I just want to say after he announces the winner, we're going to keep the call going for a few minutes. Feel free to stay on. And then after some time, we'll end the call. Okay, so I'm going to hand it over to Judge Singhal.
Okay, thank you, Lena. And one last thing before I announce the winner is you've got 4 really strong Nova connected role models here. And I know that they will look out for you, whether it's becoming an adjunct professor like Judge Marino, or working at Greenberg-Traurig like Judge Pander, or on the 4th DCA like Judge Batista, or at Wicker-Smith like Judge Foster. I mean, these are just top jobs in our legal community, and these are ways to start and build on a career, whether you become a law partner there or become a judge or whatever you want to do. And I know that you've got just great role models here. So it's time. I do have to announce it was a close call. We discussed everything, and the winner of this year's Feinrider competition is Kyle Forge. Congratulations to both of you. Congratulations, Ms. Rodriguez, as well. You both just did a tremendous job. You know, I think about it as like a tennis tournament. You have to win every round to get to that finals, and people don't sometimes realize how much you had to go through just to enter and then to make it through those rounds. So I'm so proud of both of you. I hope I get to meet you both personally whenever we are allowed to do that, and I look forward to being able to help you in any way I can in the future. But I'm really proud of you both.
Thank you so much.
Congratulations.
Congrats,
Thank
Pat.
you.
Thank you, Your Honors.
Thank you.
So with that said, we will end this, and thank you so much again. It was a pleasure having you all on here, and go back home and maybe watch the YouTube over and over. All right,
Thank
goodbye,
you,
everyone.
everybody. Bye.
Bye.
Thank you, everyone.
Hi, everyone.